Okay, so I say all lives matter, and I don't think that that's offensive. I actually believe that Black Lives Matter is a pretty extreme group with views that I don't agree with. But Rohini Sethi went on Facebook. She's a student government leader at the University of Houston. She posted after the Dallas shootings where 5 officers were killed, quote, on Facebook, quote, "Forget Black Lives Matter, more like all lives matter." She later deleted the statement, but a lot of the University of Houston students and academic officials were upset. They said that it was offensive. It's outrageous, what she said. It's so insensitive. Well, she's a member of student government, and so the student government passed a special resolution punishing her. She got a 50-day suspension from student government. She will therefore loses a stipend of $700 a month. She has to attend a diversity workshop. She has to attend at least 3 university cultural events every month from September through March. She has to write a letter of reflection about how her harmful actions have impacted the university student body. And she has to present her thoughts on September 28th, detailing what knowledge she has gained about cultural issues facing society. Is this legit? Is it even legal? Well, joining me on the DeMille Report to sort through the legal side of this stuff is Byron Henry. He's an attorney and constitutional scholar. Thanks for swinging by, Byron.
Great to be with you.
So she posts all lives matter at a public university, and somehow she's being disciplined and sanctioned for this. How in the world can someone's free speech be limited in such a way where she's sanctioned and punished for saying something that most people probably agree? All lives matter.
Well, first of all, at first blush, the university responded that this is an internal organization, that she's not going to suffer any consequences vis-a-vis the university itself, that this is basically an internal organization and that they can have their own rules and set up their own means and methods by which they govern themselves internally. And so at first blush, you think to yourself, well, that makes sense.
Wait. Hold on a minute. What if this student government passes a rule saying that black individuals may not serve in elected positions? I don't think anyone would stand for that, and that's also not appropriate under the 14th Amendment equal protection and due process rules.
Well, as I was saying, at first blush, it makes sense that organizations that can govern themselves, except that all of these organizations, they operate with the approval. They don't have independent rights to have organizations on campus. The university basically certifies, or for lack of a better term here, licenses these organizations to operate on campus. And in fact, we've seen numerous instances where conservative organizations have lost their university sanctioned status for exercising their free speech rights, which I believe is also unconstitutional. So the idea that simply because it's an internal student organization matter and the university is somehow divorced from it, I think is oversimplistic. I certainly believe the university has the authority and the obligation to step in, as you mentioned, when organizations that it has certified or licensed are running the organization in an unconstitutional or otherwise illegal manner, such as unlawful discrimination, free speech violations, religious freedom violations, where an organization simply, for instance, bans Catholics, for instance. That, of course, wouldn't be tolerated by the university. So in this case, they're tolerating, what they're doing is tolerating violation of a student's free speech rights on campus and in the university, which I think the university absolutely could take action and basically say, if you are not going to allow free speech in this organization, then we are going to decertify you as an organization. You can't operate on our campus if you don't have open free speech, if you discriminate against certain points of view in certain individuals. And I think that is perfectly legitimate for the university to do.
Of course, you and I both know they won't do that. And the victim in this case, the student that's been punished, it looks like she's accepting the punishment. In order to reverse this, wouldn't she, as the victim, have to because she's the only one that I would assume has standing, she would have to sue saying, I don't accept and I want a judge to intervene. Would that be the only redress here?
I think the most likely redress would be for her to take action, but someone also, as a member of the student government there, like this student, could file an action in federal court saying their free speech rights have been unconstitutionally chilled because they're afraid to exercise them because of what happened to this student. So she may not be the only person that has standing. She's the most likely person and that has the strongest standing, but obviously someone else on student government that would like to speak out on a controversial topic or express an opinion will think twice before doing so.
So in this school, and it's happening around the country, free speech is under assault, particularly if you're conservative. Because if you're liberal, well, oh my gosh, you're going to attack a gay person? Well, we're going to crack down on you. But if you have a conservative express a conservative view, they basically can punish you, and the university looks the other way. Let me look at this other story that came out relating to our schools as well. These are for elementary schools. And I almost fell out of my chair when I saw this one, Byron, because it almost is too extraordinary to be true, but unfortunately it is true. Headline, Satanic Temple seeks an open after-school Satan club in elementary schools. Basically, the Satanic Temple, which is actually a real organization, they don't like religion, and they've decided to threaten a elementary school in Washington, D.C., by saying that they insist on having access to the students as well as a location on the school's premises to hold an after-school extracurricular club to worship Satan. And they say if the school does not comply, they're going to sue. Now, you and I both know what they're doing is they're trying to find one school that says no, and they're going to sue on the basis of discrimination. What are your thoughts on this? Do you think that this lawsuit would be successful? Because it sounds like what they're saying is that we're no different than Christians, and we're not saying that we need sanction, but we do want equal opportunity and equal accommodations.
Well, there's two Supreme Court or constitutional doctrines at play here. One is the use of public school facilities for use by churches or any other secular or religious organization that the schools rent them out. As you know, a lot of churches rent out schools on the weekends or on Sundays for services, and as long as the school rents them out to non-religious or secular for secular activities, they have to rent them out and allow them to be used for religious activities. So that's one doctrine. This sounds more like the Good News Bible Club line of cases, which says if you allow extracurricular activities, clubs to use school premises, you have to do so on a neutral basis, meaning you can't turn down a Christian club if there is a Christian club, mind you. This is not you allow people just to come off the street. If there is a recognized club in the school, like a chess club or a Christian club or a Catholic club or whatever kind of club, you can't let some organizations meet and decide internally that you don't think it's a good idea to let the Catholics meet or the Christians, or in this case, probably the Satanists. But there's two problems with that. First of all, there has to be a club that's recognized, which means it has to have members. You're not just allowed to sue to open up a room. There has to be some child there that is a
Satan worshiper, yeah.
That's right. They want to start a club, like a book club or a Shakespeare club or a Satanist club, and that they're being denied the use of access after hours for their extracurricular club on a different basis than other people get to use the space.
So conceivably, this could be done. And I'm assuming what the Satanic Temple has done is that they've actually got a plaintiff, ready. But you think that it might actually be successful if you get the right school that has religious clubs, and the Satanists say either you ban all the religious clubs or you got to let us in?
Well, the Supreme Court has actually said you can't really ban all the religious clubs. In other words, they say if you have extracurricular clubs, liberal arts type clubs for, you have a Shakespeare club and you have a chess club and somebody wants to start a Christian club or whatever, then you have to allow equal access and you can't discriminate based on religion or no religion. So that's the first step.